Hello and welcome to the Minimum Competence episode for Monday, June 15th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, McConnell scolds DOJ over the USCIS pause, Google sues a Gemini phishing ring, and a judge blocks Trump's parks content order. Let's remember, be you never so high, the law is above you, and read today's legal news. On this day, June 15th, in legal history, in 1215, in a meadow at Runnymede on the south bank of the Thames, King John of England affixed his seal to a document the rebellious English barons had drafted, in which the king conceded a series of limits on his own royal authority. We call it Magna Carta, the Great Charter. The immediate political context was a baronial revolt against John's tax exactions for his disastrous French wars, and most of the 63 chapters as drafted in 1215 are concerned with the highly specific grievances of a feudal aristocracy: wardship, the inheritance fees of widows, the freedom of the church, the standardization of weights and measures in the king's markets, etc. The two chapters that these centuries have remembered are 39 and 40. Chapter 39 says that no free man shall be taken or imprisoned or dispossessed except by the lawful judgment of his peers or by the law of the land. Chapter 40 says that to no one will the king sell, deny, or delay right or justice. The charter was annulled by Pope Innocent III within 10 weeks of sealing. The Pope held that John, as a vassal of the Holy See, could not be bound by a treaty extracted under duress, and the country immediately collapsed into the First Barons' War. But John died in October of 1216. His 9-year-old son, Henry III's regents, reissued the charter as a tactical concession the next month. It was reissued again in 1217 and 1225, and by the late 13th century, the 1225 version had been confirmed by successive kings as a foundational statute of the realm. Edward Coke, writing in the 17th century, transformed Chapter 39's Law of the Land into the doctrine of due process, and the founding generation of the American Republic picked up Coke's reading and wrote it directly into the Fifth and 14th Amendments of the United States Constitution. The phrase due process of law in those amendments is the most consequential American inheritance from the Runnymede document. The principle that the barons were trying to extract from a beleaguered king, that the law constrains the sovereign to, is the substrate on which everything we recognize as constitutionalism is built. 811 years on, the principle is still the work. The Rhode Island travel ban lawsuit we covered on June 8th took a sharp turn on Friday. Chief Judge John J. Connell Jr. of the District of Rhode Island held a status conference in Dorcas International Institute v. USCIS, at which he was openly frustrated with the Justice Department for failing to immediately implement his June 5th vacatur of the 4 USCIS benefit freeze policies for nationals of the 39 travel ban countries. The judge's message, in plain terms, was that the vacatur under the Administrative Procedure Act is self-executing. The moment the order was entered, the policies ceased to exist, they ceased to be, and the agency was obligated to resume processing affirmative benefits, asylum claims, and adjudicator instruction reviews on the prior pre-freeze basis. The Trump administration, after the hearing, told the court it would comply, restart adjudications, and clear the backlog. It also did what defendants typically do when they have lost on the merits and lost again on compliance. It filed a notice of appeal with the First Circuit and asked the appellate court to stay the vacatur pending appeal. That is the live question today. The First Circuit stay analysis runs through the standard Niken v. Holder factors: likelihood of success on the merits, irreparable harm, the balance of equities, and the public interest. And the administration's strongest argument on each is going to be familiar. The executive needs administrative breathing room to implement a travel ban. Mass restoration of adjudications creates national security risk. The harm to applicants is reversible if their adjudications are paused for a few more weeks, etc. The plaintiff's strongest counter-arguments are also familiar. The policies were unlawful when adopted, and the agency had no business adopting them. The harm to applicants from continued delay is concrete and accruing daily, and the First Circuit is not in the business of staying vacators of unlawful agency action in order to let the agency continue acting unlawfully. Watch the First Circuit's calendar this week. The stay motion is the next inflection point. Google filed suit on Friday in the U.S. District Court for the Southern District of New York against a China-based cybercrime network it calls the Outsider Enterprise, alleging that the network's members use Google's Gemini large language model to generate the code, copy, and templates for phishing-as-a-service platforms that have built more than 9,000 fraudulent websites and sent 2.5 million scam text messages in the 2 weeks ending June 1st alone. The complaint is significant for two reasons. First, it is, to Google's knowledge, the first time the company has affirmatively sued threat actors for using its own generative AI product as the input to a scaled criminal enterprise, as distinct from the more usual posture of suing scammers who impersonate Google brands. The legal theories are a mix of Lanham Act false designation of origin and trademark infringement counts, Computer Fraud and Abuse Act counts based on outsiders' unauthorized access to Google services, breach of conduct counts on the Gemini terms of service, and a RICO count. Second, the factual record will be a roadmap for the next decade of AI misuse litigation. The complaint describes Telegram channels in which outsider members trade prompts that get Gemini to write phishing code, a library of 290 pre-built templates impersonating brands ranging from the U.S. Postal Service to state DMVs to EasyPass, and an FBI estimate that the broader campaign Outsider participates in has stolen roughly 3.87 million card numbers and caused $1.9 billion in losses since July of 2023. The remedy Google is seeking is a permanent injunction shutting the operation down, plus domain seizures and account terminations across Google services and at major U.S. carriers, which Google says it has been coordinating with the FBI, AT&T, T-Mobile, and Verizon. The deeper legal question the case may end up clarifying is whether and to what extent platforms can use private civil suits as the frontline enforcement mechanism against AI-augmented criminal activity that the public criminal justice system has had trouble keeping up with. A federal district judge in Washington on Friday issued a preliminary injunction barring the Trump administration from continuing to implement Executive Order 14253, the order under which the National Park Service had been scrubbing exhibits, signage, and online materials at sites administered by the Department of the Interior. The judge gave the administration 3 weeks to restore the materials it had already removed. The order at issue, signed in March, directed federal cultural agencies to identify and remove content that, in the executive's view, reflected, quote, improper, divisive, or anti-American ideology or partisan framing. In the months that followed, the National Park Service had taken down or altered displays addressing slavery, the civil rights movement, the internment of Japanese Americans during the Second World War, climate change, and the histories of Native American dispossession at sites, including the Stonewall National Monument, Independence Hall, and the Manzanares National Historic Site. The case is American Historical Association v. Department of the Interior, brought by historians, professional associations, and a coalition of plaintiffs that includes affected park employees and visitor experience contractors. The legal theory pleaded was a multi-strand one. First Amendment viewpoint discrimination as applied to government speech that has taken on a public forum character, Administrative Procedure Act challenges on the ground that the agency failed to provide a reasoned basis for the removals and failed to consider statutory commands under the Organic Act of 1916, and a Federal Records Act challenge to the destruction of materials that constituted federal records. The judge held that the plaintiffs were likely to succeed on the First Amendment claim and the APA claim, found irreparable harm in the ongoing loss of public access to the underlying historical materials, and found that the public interest was best served by restoration. The administration is widely expected to appeal to the D.C. Circuit. In the meantime, the 3-week restoration clock is ticking. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here on Monday. And until then, remember, success is just failure in a nicer outfit.